Ma'am, I'm going to need to see some identification. What are you doing in this office? County Justice Center, second floor. Tuesday morning, 9:47 a.m. Fluorescent lights hummed overhead. The muffled sound of conversations and footsteps echoed from the marble hallway outside. Case files sat stacked neatly on the mahogany desk. Magistrate Diane Whitmore looked up from the warrant applications she was reviewing. She was wearing her black judicial robe. Her nameplate sat prominently on the desk. Magistrate Diane Whitmore, Division 3. Officer, I'm Magistrate Whitmore. These are my chambers. Is there an emergency I should know about? The officer's hand remained near his service weapon. His jaw was set. I don't know who you are, and I need you to step outside this office right now. What happened in the next 8 minutes would expose a dangerous pattern the department had ignored for 3 years and end a career permanently. To understand the magnitude of this moment, we need to know exactly who was sitting behind that desk. Magistrate Diane Whitmore, 41 years old, presiding judge of County Magistrate Court, Division 3. She had graduated summa cum laude from Howard University in 2004 with a degree in political science. 3 years later, she earned her JD from Georgetown University Law Center, where she served as an editor on the Law Review. She graduated in the top 10% of her class. Her career path was impressive by any standard. 5 years as a public defender, where she tried over 200 felony cases. 3 years as an assistant district attorney with an 89% conviction rate. 3 years in private practice focusing on civil rights litigation. And since 2018, 7 years on the magistrate bench. In those 7 years, Magistrate Whitmore had presided over more than 12,000 cases. She'd issued 8,500 warrants. She'd conducted 3,200 probable cause hearings. But her most significant assignment was the one she'd held for the past 4 years: preliminary hearings for police misconduct complaints, excessive force allegations, wrongful arrest claims, constitutional violations. She reviewed them all. She had co-authored 2 law review articles on Fourth Amendment protections and qualified immunity. She was known among local attorneys and law enforcement as meticulous, fair-minded, and uncompromising on constitutional standards. Chief Magistrate Donald Freeman once said of her, "Diane is one of the most thorough, fair-minded jurists we have. Officers know that when they come before her, their work better be constitutional and their paperwork better be flawless." She mentored young black attorneys through the National Bar Association. She spoke at local high schools about constitutional rights. She'd been married for 15 years and had 2 teenage daughters. On that Tuesday morning in February, she was reviewing warrant applications for the afternoon docket, including 2 excessive force complaints scheduled for preliminary hearings at 2:00 p.m. But in the next few minutes, none of that would matter. Officer Derek Paulson, 34 years old, badge number 2847, 6 years with the county sheriff's department. Paulson had grown up in a rural county 40 miles away. His father had been a corrections officer. He'd attended community college for 2 years before dropping out sophomore year. He joined the department at 28. He graduated from the police academy, ranked 34th out of 67 cadets, middle of his class. He'd completed all required continuing education courses, but held no advanced certifications. For the past 8 months, he'd been assigned to court security detail, screening visitors, maintaining courthouse order. Before that, he'd been on patrol. His reassignment came after what department records called concerns about inappropriate traffic stops. Supervisor evaluations described Paulson as adequate and sometimes overly assertive. He'd received 1 commendation in 2019 for subduing a combative defendant. But there was something else in his personnel file. 7 citizen complaints in 6 years. The department average was 1.2 complaints per officer. 2019, excessive force allegation, dismissed, investigated by his then sergeant. 2020, 2 complaints for disrespectful conduct, both marked unfounded. 2021, false arrest claim, The county settled for $12,000. Paulson received no discipline. 2022 racial profiling complaint, dismissed as unsubstantiated. 2023 two more excessive force complaints, both investigated by the same supervisor, both dismissed. 6 of those 7 complaints came from black citizens. Every investigation had been conducted by his direct chain of command. No external review was ever performed. His previous sergeant, who had retired in 2023, had dismissed 19 complaints against his officers in 5 years. Colleagues later described Paulson as someone who saw threats everywhere and didn't like being questioned. Derek Paulson considered himself a good cop doing a difficult job. On February 14, 2024, he was about to discover what happens when assumptions meet authority. February 14, 2024, Valentine's Day, Tuesday morning, clear winter skies, 38 degrees. Magistrate Whitmore had arrived at the courthouse at 7:45 a.m., as she did every Tuesday. She conducted first appearance hearings from 8:00 to 9:30, a steady stream of defendants appearing on video from the county jail for bail determinations. At 9:30, she returned to her chambers to prepare for the afternoon docket, specifically 2 police misconduct preliminary hearings scheduled for 2:00 p.m. She'd been in her chambers for 17 minutes, door partially open per her usual practice, when Officer Paulson walked past on what he later called a security sweep. Her black judicial robe was clearly visible. Her name badge sat on the desk. The door to her chambers was marked with the judicial seal and a nameplate reading, Magistrate Diane Whitmore. Paulson would later claim he didn't recognize her and thought she looked suspicious. There was no dispatch call, no complaint, no emergency. He acted entirely on his own initiative. What Officer Paulson didn't know, or chose to ignore, was that the woman he was about to confront had reviewed 47 of his arrest reports in the past year. She had denied his warrant applications 11 times for constitutional deficiencies. At 9:47 a.m., without knocking, without announcing himself, and without any legal justification whatsoever, Officer Derek Paulson entered Magistrate Whitmore's chambers. What followed was captured on his body camera. Whitmore looked up to see Officer Paulson pushing her chamber door fully open. His hand rested on his duty belt near his handcuffs. "Ma'am, I'm going to need to see some identification. What are you doing in this office?" Her first reaction was confusion, then controlled disbelief. "Officer, I'm Magistrate Whitmore. These are my chambers. Is there an emergency I should know about?" "I don't know who you are, and I need you to step outside this office right now." She gestured toward the nameplate on her desk, then to the door behind him. "Officer, my name is on both the door and my desk. I'm a county magistrate. What reasonable suspicion do you have to detain me?" "Ma'am, don't make this difficult. I'm conducting a security check and you need to comply." Whitmore's mind raced. She'd been in this courthouse for 7 years. Her name was on the door. She was wearing judicial robes. A security check of a magistrate's chambers during business hours. She reached slowly into her robe pocket and removed her judicial identification badge. She held it at eye level. "This is my judicial identification, issued by the county court administrator. Badge number M073. You can verify this with courthouse security downstairs." The badge bore the official county seal, her photograph, and the word magistrate printed clearly across the top. Paulson glanced at it for less than 2 seconds. "Anyone can get a fake ID. I need you to come with me to verify your identity." "Officer Paulson," she read his name badge carefully, "I've been presiding in Division 3 for 7 years. I have cases on the docket this afternoon. You have no legal basis to detain me. Look, I don't know how you got in here, but you need to stop resisting and cooperate." Whitmore's voice remained steady, but her next question was pointed. "Resisting what exactly? I haven't moved from my desk. What crime do you suspect me of committing?" No answer, just a repeated demand. Step outside now. Whitmore stood, but she didn't move toward the door. Officer, you are currently in a magistrate's judicial chambers without invitation, without a warrant, and without exigent circumstances. Under the Fourth Amendment, I have every right to be here. This is my workplace. You are violating my rights and judicial independence. Just cooperate, and this will be over quickly. Am I being detained? If so, under what probable cause? I'm conducting an investigation. Investigation of what crime? Be specific. You've observed me sitting at a desk in judicial robes in an office with my name on it. What reasonable suspicion exists? Paulson's tone hardened. I don't have to explain myself to you. You either come with me voluntarily, or I'll place you under arrest for obstruction. In that moment, Whitmore realized he was serious. He was actually going to arrest a sitting magistrate in her own chambers. She had to make a choice: comply under unlawful arrest or continue asserting her rights. Officer Paulson, I am not resisting. I am asserting my constitutional rights. I will not voluntarily leave my chambers without legal justification. If you proceed with an arrest, you will be violating clearly established law. Paulson reached for his handcuffs. Stand up. You're under arrest for obstruction of a law enforcement officer and trespassing. The absurdity of the words hung in the air. Trespassing in my own chambers. Whitmore stood slowly, keeping her hands visible, her voice steady. I am complying under protest. I am Magistrate Diane Whitmore, Division 3, County Magistrate Court. Your badge number is 2847. This interaction is being recorded on your body camera. I will be filing a formal complaint and legal action. The handcuffs clicked into place behind her back, not painfully tight but unmistakable. The time is approximately 9:52 a.m. You have handcuffed a sitting magistrate without probable cause. I am asking you directly, have you verified my identity with courthouse administration? We'll verify it at the station. At that moment, Magistrate Harold Chen walked past the open door. He stopped mid-stride, his face registering shock. Derek, what the hell are you doing? That's Magistrate Whitmore. Paulson's body language shifted. Uncertainty flickered across his face, but he didn't remove the handcuffs. Judge Chen's voice rose. Remove those handcuffs immediately. I'm ordering you as a judicial officer to release her. Whitmore spoke calmly, deliberately. Judge Chen, please document this. Officer Paulson has arrested me in my chambers without cause. I need you to contact the Chief Magistrate and Court Security Supervisor immediately. 73 seconds passed before Paulson's supervisor arrived. 73 seconds that would cost him everything. Sergeant Maria Torres arrived within 90 seconds of Judge Chen's radio call. She recognized Whitmore immediately. The color drained from her face. Paulson, remove those cuffs right now. Magistrate Whitmore, I am so sorry. Whitmore's voice remained calm, professional but firm. Sergeant Torres, I appreciate your response, but I need this documented properly. Officer Paulson has violated several clearly established constitutional protections. The handcuffs came off. Whitmore rubbed her wrists where red marks were already forming. She turned to Paulson. Officer, I'm going to ask you some questions. Sergeant Torres, please listen carefully. What reasonable suspicion did you have to initiate contact with me? Paulson shifted his weight. You looked out of place. Out of place, in my own chambers, wearing judicial robes, with my nameplate visible on the desk and door. Silence. What criminal activity did you observe? No answer. Did you verify the office assignment before entering? No, ma'am. Did you radio courthouse security to ask who occupies Division 3 chambers? No. Did you notice the judicial seal on the door? I wasn't focused on that. Whitmore's next question hung in the air like an indictment. Officer Paulson, I've been on this bench for 7 years. I've reviewed dozens of your arrest reports. I've denied 11 of your warrant applications for constitutional deficiencies. What made me look suspicious today? The silence that followed answered the question. Your actions violated my Fourth Amendment rights against unreasonable seizure, judicial independence protections under state law, and department policy on detention procedures. You had no probable cause, no reasonable suspicion, and no exigent circumstances. She turned to Sergeant Torres, who was already on her radio. This body camera recording will show I identified myself immediately, presented credentials, explained my authority, and did not physically resist. It will also show Officer Paulson proceeded with the arrest anyway. Torres' voice was tight. Magistrate Whitmore, I'm placing Officer Paulson on immediate administrative leave. I'm notifying the Chief Deputy and Internal Affairs right now. Whitmore nodded. I will be filing a formal complaint with Internal Affairs, a judicial misconduct report with the sheriff, and consulting with civil rights attorneys regarding legal action. This isn't about me personally, it's about a pattern that needs to end. Paulson finally spoke. I was just doing my job. Whitmore's response was cutting. Your job is to protect constitutional rights, not violate them. You arrested a magistrate in her chambers based on zero evidence of criminal activity. That's not law enforcement. That's something else entirely. Officer Derek Paulson left the courthouse within 20 minutes. Badge and service weapon surrendered to Sergeant Torres. He would never return. But the full irony of what had happened wouldn't become clear until later that afternoon. Magistrate Whitmore's 2:00 p.m. docket included 2 preliminary hearings on excessive force complaints. Both cases involved Officer Derek Paulson as the defendant officer. She had been scheduled to determine whether probable cause existed to believe Paulson had violated citizens' constitutional rights. Records would later show that Whitmore had presided over 47 of Paulson's arrest cases in the past 2 years. She had denied 11 of his warrant applications for constitutional deficiencies. She had sustained 3 defense motions to suppress evidence from his searches. Internal Affairs would investigate whether Paulson recognized her and retaliated. Either scenario was damning: intentional retaliation or such profound disregard for judicial authority that he arrested a magistrate he should have known. By 11:30 a.m., Chief Magistrate Donald Freeman had convened an emergency meeting with all magistrates. He called Whitmore's arrest an assault on judicial independence. Whitmore recused herself from both Paulson-related hearings due to the obvious conflict of interest. The cases were reassigned to Judge Chen. Both resulted in probable cause findings against Paulson. Sheriff Robert Kowalski personally called Whitmore at 12:30 p.m. to apologize. By 2:00 p.m., his office had announced a formal internal affairs investigation. The body camera footage was secured immediately. Copies were provided to the county attorney's office and Whitmore's attorney by end of day. That evening, Whitmore went home to her family. Her wrists still bore the marks from the handcuffs. She had to explain to her teenage daughters why their mother, a judge, had been arrested at work. The investigation that followed would take 11 weeks. What investigators found went far beyond one officer's actions in one magistrate's chambers. Internal Affairs assigned 2 senior investigators, Sergeant Nicole Bradford and Lieutenant James Park. Both had extensive civil rights investigation training. Neither had worked in Paulson's chain of command. They spent 11 weeks building the case. They reviewed 18 hours of Paulson's body camera footage from the past 2 years. They analyzed 847 dispatch records. They examined his complete personnel file, training records, evaluations, every previous complaint investigation. They reviewed 213 arrest reports for demographic patterns and legal sufficiency. They interviewed 23 people: magistrates, deputies, individuals Paulson had arrested, courthouse staff. Magistrate Whitmore sat for 2 detailed interviews totaling 6 hours. She provided case files documenting her rulings on Paulson's work. Paulson was interviewed twice. His defense was consistent. He didn't recognize Whitmore. He was following training on security protocols. He denied any racial motivation. He claimed he would have done the same to anyone acting suspiciously. Investigators found a critical detail. Courthouse security protocol specifically exempted judicial chambers from officer sweeps without invitation or emergency. Paulson had no authority to enter Whitmore's chambers at all. But it was what they found in his complaint history that proved most damning. 7 citizen complaints over 6 years, all 7 reviewed in detail. Marcus Thompson, 2021. Black social worker arrested for trespassing while eating lunch in a public park across from his office. Charges dropped. Civil suit settled for $12,000. Thompson told investigators, "I showed him my work ID. He said I was loitering. When I asked what law I was breaking, he arrested me for questioning him." Attorney Jasmine Reeves, 2022. Black female attorney stopped in the courthouse parking garage while walking to her car after a trial. Paulson demanded ID, claimed she matched the description of a suspicious person. No incident report was ever filed. Reeves said, "I was in a business suit carrying a briefcase with my firm's name on it. He asked me what I was doing in the parking garage. I told him I was an attorney. He said, 'Sure you are.'" Deshaun Williams, 2023. Black teenager arrested for resisting during a high school football game disturbance. Excessive force complaint sustained but resulted only in counseling. Williams told investigators, "He grabbed me from behind, no warning. When I turned around startled, he said I was resisting. He never told me why he grabbed me in the first place." The demographic pattern was stark. A commissioned data analyst reviewed all 213 of Paulson's arrests. Black individuals represented 67% of his arrests. The county's black population was 23%. White individuals represented 21% of his arrests. The county's white population was 58%. Use of force was applied in 34% of arrests involving black subjects, only 8% involving white subjects. Magistrates had rejected Paulson's warrant applications at an 18% rate. The department average was 4%. Every one of the previous complaints had been investigated by former Sergeant Ronald Hughes, Paulson's supervisor, until his retirement in 2023. Hughes had conducted each investigation in 2 to 3 weeks, minimal witness interviews, no body camera review in 4 of the 6 cases he investigated. The investigators noted that Hughes used nearly identical report language across multiple investigations. The investigation report's conclusion was unequivocal. Officer Paulson's arrest of Magistrate Whitmore was not an isolated error in judgment. It was the inevitable result of years of biased policing that supervision failed to correct. The arrest of a sitting magistrate finally exposed what multiple black citizens had been reporting for years. Officer Paulson enforces the law based on his assumptions about who belongs where, not on evidence of criminal activity. Civil rights attorney David Chen, retained by the county to review the findings, added, "This is textbook discriminatory policing protected by inadequate supervision." Officer Paulson demonstrated a pattern of perceiving black individuals as inherently suspicious or noncompliant, and Sergeant Hughes consistently validated that perception by dismissing legitimate complaints. On May 3, 2024, the investigation report landed on Sheriff Kowalski's desk. The recommendation was termination, but the consequences would reach far beyond one officer's badge. Sheriff Kowalski terminated Derek Paulson on May 10, 2024, effective immediately. The termination letter cited egregious constitutional violations, pattern of discriminatory enforcement, and conduct unbecoming an officer. The Sheriff's Deputies Union initially filed a grievance challenging the termination. 3 weeks later, after reviewing the body camera footage and investigation report, the union quietly withdrew its support. They declined to fund Paulson's appeal. There was no defense for what the camera had captured. The county district attorney reviewed the case for criminal charges, while he declined to prosecute, determining the conduct didn't meet the criminal threshold for false imprisonment. He issued a public statement condemning Paulson's actions as a profound violation of constitutional principles. In June 2024, Magistrate Whitmore filed a federal civil rights lawsuit under 42 U.S.C. Section 1983. In December 2024, the county settled for $2.4 million. The settlement included no admission of liability, but acknowledged the incident should not have occurred. Whitmore donated $400,000 of the settlement to a legal defense fund for individuals wrongfully arrested. In August 2024, the State Peace Officers Standards and Training Commission held an administrative hearing. They voted unanimously to revoke Paulson's law enforcement certification permanently. He cannot work as a peace officer anywhere in the state. His revocation was entered into the National Decertification Database. Paulson filed for divorce in July 2024. He declared bankruptcy in October. He relocated out of state and now works in private security, without arrest authority, in another state. He has never publicly apologized. His attorney's statement claimed he was doing his job as trained and characterized the situation as an unfortunate misunderstanding. The financial toll on the county was staggering. Civil settlement, $2.4 million. Legal defense costs, $340,000. Investigation costs, $85,000. Compliance and reform implementation, $1.2 million. Total financial impact, $4.025 million. The department's liability insurance premiums increased 34% for the 2025 policy year. Former Sergeant Ronald Hughes, already retired, faced a post-commission decertification hearing for his investigative failures. That hearing is still pending. Courthouse Security Director Martin Wells resigned 2 days after the incident. He should have trained Paulson on judicial chamber protocols. The court security lieutenant was demoted to sergeant and reassigned to patrol for inadequate supervision. Sheriff Kowalski faced no discipline but received significant public criticism. He issued a comprehensive public apology and committed to sweeping reforms. Community trust ratings for the department dropped 28 percentage points in a March 2024 survey. Recruitment applications declined 40% in the following year. The department's existing federal consent decree, from a 2021 civil rights investigation, was extended 2 additional years because of this incident. 2 backup deputies who responded but failed to intervene received written reprimands for failure to intervene. But Derek Paulson's termination was just the beginning. The department implemented 8 major reforms. 1. All excessive force and discrimination complaints are now investigated by a newly created independent professional standards division, staffed by civilian investigators with no ties to the chain of command. 2. A community oversight board with 9 appointed civilian members reviews all investigations and approves disciplinary recommendations. 3. An early intervention system now tracks use of force incidents, complaints, warrant denials, arrest demographics, and supervisor feedback. Officers are automatically flagged for review after 3 complaints in 12 months, use of force 25% above peer average, or warrant denial rates 10% above department average. 4. 5% of all body camera footage is now randomly reviewed each month. Previously, footage was only reviewed after complaints. 5. Body camera retention was extended from 60 days to 2 years for all law enforcement contacts. 6. Officers cannot enter judicial chambers without invitation, warrant, or articulated emergency. Violation results in automatic 5-day suspension. 7. Constitutional law training increased from 12 hours to 24 hours in the academy, with an 8-hour annual refresher. Implicit bias training increased to 8 hours annually. 8. A new policy, informally called the Whitmore Protocol, requires officers to radio dispatch for verification before detaining any government official. The department reviewed all 847 cases Paulson had handled. 3 additional wrongful arrests were identified. The county offered settlements to those individuals. The early intervention system flagged 7 other officers with similar complaint patterns. 4 were placed on performance improvement plans. 2 were terminated during their probationary periods. The sheriff's office launched an 18-stop listening tour in diverse neighborhoods across the county. Feedback was used to refine policies further. The case received national media coverage. Whitmore was interviewed on CNN and MSNBC. The Daily podcast featured a 30-minute episode on the incident. Whitmore's body camera footage, with her permission, is now used in 23 state police academies and 47 law schools as a training example of unlawful detention. In 2025, the state legislature passed the Judicial Protection Act, making it a felony to knowingly detain a judicial officer without lawful authority. The law was a direct result of Magistrate Whitmore's case. Magistrate Diane Whitmore still presides in Division 3. In January 2025, she was promoted to senior magistrate, the highest rank in the magistrate court system. She now serves on the county's Criminal Justice Reform Commission. She speaks at police academies and law schools nationwide about judicial independence and constitutional policing. She has consulted with 12 other jurisdictions on complaint investigation reforms. In November 2024, she co-authored a law review article titled, "When Badges Meet Benches: Protecting Judicial Independence from Police Overreach." It has already been cited in 8 subsequent court opinions. In a recent interview, she reflected on the incident. "I had the education, the position, and the protection of my judicial office. I knew my rights and had the power to enforce accountability. But I keep thinking about Marcus, Jasmine, Deshaun, all the people who experienced the same bias but didn't have institutional power to fight back. That's who this was really about." 18 months after the incident, the reforms are working. The department's average complaint investigation time dropped from 127 days to 34 days. The Civilian Oversight Board has sustained 41% of excessive force complaints, compared to just 3% under the previous internal process. The Whitmore case is now taught in 23 state police academies as an example of what happens when bias replaces evidence-based policing. It teaches a simple but powerful lesson. Credentials don't protect you from bias. Authority doesn't protect you from bias. Even a magistrate in her own courthouse wasn't immune. If it happened to her, it can happen to anyone. The Fourth Amendment requires reasonable suspicion, specific articulable facts suggesting criminal activity, to detain anyone, not assumptions, not feelings, not bias about who belongs somewhere. Body cameras only matter if the footage is reviewed and acted upon. Paulson's previous incidents were all captured on camera. None were examined until Magistrate Whitmore's arrest forced a comprehensive review. Accountability requires multiple layers: individual consequences, supervisory accountability, civilian oversight, transparent data, community engagement. No single reform solves systemic problems. February 14, 2024. A sitting magistrate was handcuffed in her own chambers by an officer whose constitutional violations she'd been documenting for 2 years. The body camera that recorded her unlawful arrest is now used to train officers in 23 states on what reasonable suspicion actually requires. That's how accountability works. When institutions finally confront the patterns they've been ignoring, one officer's misconduct becomes everyone's lesson. If you've experienced being questioned for simply existing in a space where you had every right to be, at your workplace, in your neighborhood, during everyday activities, you're not alone. Magistrate Whitmore's story resonates because it's a more visible version of what countless people experience without cameras, without institutional power, and without recourse. This channel documents these cases because evidence-based accountability is how systems change. Every view, every share, every conversation helps these stories reach people who need to see them: community members learning their rights, officers seeing what accountability looks like, policymakers understanding what needs to change. Know your rights, demand accountability, document everything. Because evidence doesn't lie. Bias does. Thanks for watching.